Hello students, my name is Abhishek Sudhir. I am an assistant professor at the Jindal Global Law School. Welcome to EPG Pathshala. Today we'll be discussing Module 8, Right to Free Speech and Expression under the Constitution of India, which forms a part of paper number 4 on the civil and political rights. The right to free speech and expression is a right that has been given a wide and expansive interpretation by the Supreme Court of India. At the same time, the Supreme Court has also sought to restrict the ambit of the right. An environment in which one can feel free to express one's thoughts and opinions without any hesitation or fear is essential for the social, economic, and cultural progress of the country, is what the Supreme Court has said. The Supreme Court has, with this in mind, interpreted Article 19(1)(a) of the Constitution in a liberal manner and has judicially created several rights, some of which could not have been anticipated by the framers of the Constitution themselves. This module will discuss some of these constitutional developments in which the right to freedom of speech and expression has been used to protect rights not explicitly mentioned in the Constitution but implicit in its spirit. What are the learning outcomes of this module? The purpose of this module is to give the students an overview of the constitutionally recognized components of an individual's right to freedom of speech and expression. The module also hopes to help the student understand the manner in which the right to freedom of speech and expression is protected by the Constitution of India and the role the Supreme Court has played in this. Now, let's start with Article 19(1)(a) of the Constitution. 19(1)(a) states that all citizens shall have the right to freedom of speech and expression. However, Clause 2 imposes certain restrictions on this right. Those restrictions are contained in the following clause. Nothing in subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. Now, here is where the Supreme Court of India comes in. They will have to interpret what is a reasonable restriction. They have to interpret whether that restriction is in the interest of the sovereignty and integrity of India. They have to interpret whether that reasonable restriction is in the interest of the security of the state. They have to interpret whether that reasonable restriction is in furtherance of friendly relations with foreign states. They have to interpret if that restriction is in the interest of public order, decency, or morality. What is the meaning of decency? What is the meaning of morality? These are things that the Supreme Court has to interpret and elucidate. The Supreme Court also has to see if those reasonable restrictions relate to contempt of court or defamation. What is defamation? To incitement of an offense. Therefore, it is the Supreme Court of India that is the last line of defense between a society that guarantees free speech and a society that seeks to curb free speech. The text of the Constitution is simple and brief and does not answer questions such as what constitutes expression or as to whether the freedom of the press is protected. These questions have been answered by the Supreme Court in its various judgments. Let's start with the landmark case of Menaka Gandhi versus Union of India, a case that was decided in the aftermath of the emergency. India is a democratic nation, and democracy is entwined with the concept of free speech. Democracy is, after all, based on the idea that every person should have his or her say in the government, i.e., it is a government of the people, by the people, and for the people. And if you're in constant fear of speaking up, criticizing that government, then what kind of government is it? Is it your government? It certainly isn't. As the Supreme Court has observed in Menaka Gandhi's case, and I quote, democracy is based essentially on free debate and open discussion. For that is the only corrective of government action in a democratic setup. If democracy means government of the people, government by the people, it is obvious that every citizen must be entitled to participate in the democratic process. And in order to enable him to intelligently exercise his right of making a choice, free and a general discussion of public matters is absolutely essential. Now, let's come to some semantics surrounding the right to freedom of speech and expression. One interesting question is, does the freedom of speech and expression include the freedom not to be forced to be receptive to one's speech and expression? To put it another way, we know that freedom of speech and expression includes the freedom to express opinions. Conversely, does it include the freedom to not be forced to be receptive to these ideas? Answering in the affirmative, the Supreme Court has held that this right comprehends the freedom to be free from what one desires to be free from. Essentially, individuals cannot be forced to listen to something they just don't want to. And this is where the case of loudspeakers comes into the picture. Imposing a ban on the use of loudspeakers, the court observed that a loudspeaker forces a person to hear what he wishes not to hear. He might wish to hear it, but right next to him might be another individual who does not wish to hear it. The court has also held that the use of a loudspeaker is incidental to the exercise of the right, but in and of itself does not constitute a right to express opinions. What that basically trying to say is, speaking into the loudspeaker only amplifies what you're saying. It is not crucial to what you're saying. It is only incidental to what you're saying. It is only incidental to your speech. Now let's come to the right to receive information. In a public interest litigation filed by the People's Union for Civil Liberties, the issue was whether a voter has the right to receive relevant information, such as assets, qualification, and involvement in offences for being educated and informed for judging the suitability of a candidate contesting elections as an MP or an MLA. A public interest litigation is a device that the Supreme Court has essentially invented. Under a PIL, an ordinary citizen of the country can approach the court on behalf of a marginalized group of citizenry that is unable to approach the court. Filing a PIL, the PUCL, the People's Union for Civil Liberties, sought to get a clear answer from the Supreme Court on whether the right to free speech and expression included the right to receive information. The court held that the right of the citizens to obtain information on matters relating to public acts flows from the fundamental right enshrined in Article 19, 1A. Having access to the basic details of candidates contesting elections for parliament or state assemblies will help the voter make an informed choice when exercising his or her franchise, said the Supreme Court. Thus, the right to information has been held to be an intrinsic part of Article 19 by the Supreme Court of India. Now let's deal with the bogey of the freedom of the press. As some of you might know, freedom of the press is not explicitly granted in Article 19, but is it implicit? The makers of India's constitution certainly thought so. However, the government in the 1970s, headed by Srimati Indira Gandhi, in order to curb the freedom of the press, put in place a newsprint policy. The policy imposed ownership restrictions, limits on the number of pages a newspaper could carry, among other things. The government justified these restrictions as a manner of regulating the supply of the newsprint quota to newspapers. They said they were not interfering with the freedom of the press. All they were trying to do was to regulate the amount of newsprint quota that was supplied to the newspapers, thereby reducing the size of the newspaper. They said the newspapers were still free to print whatever they wanted to, as long as they stayed within the page limit of the newspaper. This is the famous case of Bennett Coleman and Co. versus Union of India. Bennett Coleman, as some of you might know, owns the Times of India. The Supreme Court held that the object of the policy was not relevant, as the restrictions were excessive and prohibitive, thereby directly affecting the circulation of newspapers. The court held that the liberty of the press included the right to free propagation and free circulation without any prior restraint. This is a very important sentence in the judgment of the Supreme Court. They said free propagation and free circulation without any prior restraint. By imposing the amount the newspapers could publish, what the government of the day was essentially doing was also restricting what they could publish. And that was a direct violation of the freedom of the press that is granted implicitly in Article 19(1)(a). in a similar case of Mysore Printers Limited versus the Assistant Commercial Tax Officer, the government, through an amendment, excluded newspapers from the purview of goods and consequently charged a higher rate of tax on newspapers. The Supreme Court struck down the amendment, and a passage from the judgment is worth quoting in extenso. I quote, "Freedom of the press is not expressly guaranteed as a fundamental right. It is implicit in the freedom of speech and expression. Freedom of press has always been a cherished right in all democratic countries. The newspapers not only purvey news, but also ideas, opinions, and ideologies, besides much else. They are supposed to guard public interest by bringing to the fore misdeeds, failings, and lapses of the government and other bodies exercising governing power. Rightly, therefore, it has been described as the fourth estate. The democratic credentials of a state are judged today by the extent of freedom the press enjoys in that state. It is therefore beyond any doubt that the freedom of the press is guaranteed and enshrined in the Constitution of India. Now let's come to the rather notorious case of the Cricket Association of West Bengal versus Doordarshan. The Cricket Association of West Bengal was denied permission by Doordarshan to telecast cricket matches through a frequency not owned or controlled by the government of India, but owned by a foreign satellite agency. The Ministry of Information and Broadcasting stance aggrieved the CAB, the Cricket Association of Bengal. The Cricket Association of Bengal approached the court arguing that the game of cricket provided entertainment. They felt cricket was a national sport and their right to telecast these matches being infringed upon by the Ministry of Information and Broadcasting was a direct violation of their Article 19(1)(a) rights. The court, in agreement with the petitioner, the Cricket Association of Bengal, held that freedom of speech and expression includes the right to acquire information and to disseminate the same. Essentially, the CAB had the right to acquire the feed from the foreign satellite agency and then disseminate it across the country through the television channels. The right to communicate, therefore, means the right to communicate through any media that is available, whether print or electronic, or audiovisual, such as advertisements, articles, speech, etc., and includes the freedom to communicate and circulate one's views. The right to freedom of speech and expression includes the right to educate, the right to inform, and to entertain, and also the right to be educated, informed, and entertained. The former, the right to entertain, is the right of the telecaster, and the right to be entertained is the right of the viewers. Therefore, the right to impart and the right to receive is a species of the right to freedom of speech and expression, and a citizen has the right to use the best means possible of imparting and receiving information. Now let's come to the rather tricky issue of commercial speech, which is to be distinguished from non-commercial speech. In a case where Tata Press Limited wanted to publish a telephone directory, the Mahanagar Telephone Nigam Limited, MTNL, forbade them from doing so, claiming an exclusive right to publish telephone directories under the Telegraphs Act 1885. The court rejected MTNL's contention and held that commercial advertisement is a form of speech and expression as they disseminate information through advertisement. So essentially, what the court said was Tata Press Limited had every right to publish the telephone directory. Now let's come to the right to remain silent and the right to demonstration. In a case where the government had imposed a complete ban on civil servants from participating in any form of demonstration, striking down the rule in question, the court held that demonstrations being visible representation of ideas would be protected as a form of speech, provided they are not violent and disorderly. In this case, Kameshwar Prasad, a civil servant, petitioned the court, whereby his right to participate in a demonstration was denied by the state. The Supreme Court simply said that Kameshwar Prasad was a citizen of this country first and then a civil servant. And as a citizen of this country, he had every right to take part in a peaceful demonstration. And that formed an intrinsic part of his Article 19 rights. In another case, the court has held that Article 19(1)(a) includes in itself the right to remain silent. Again, you might hold an opinion, but nobody can force you to actually impart, or nobody can compel you to impart or express that opinion or view. Now, let's come to the interesting case of a right against telephone tapping. A PIL was filed by PUCL again in the wake of a leaked report. The report, titled Tapping of Politicians' Phones, was allegedly written by the Central Bureau of Investigation, the CBI. The court held that telephone tapping, unless it comes within the grounds of restrictions under Article 19, Clause 2, would infract Article 19(1)(a) of the Constitution. It further held that the right to freedom of speech and expression is guaranteed under Article 19(1)(a) of the Constitution. This freedom means the right to express one's convictions and opinions freely by word of mouth, writing, printing, picture, or any other manner. So, they said that when a person is talking on a telephone, he is exercising his right to freedom of speech and expression. And unless tapping of that phone is a reasonable restriction under Article 19(1)(a), then it would be unconstitutional. Let me explain further. The government believes that individual A, who is a citizen of the country, is a suspected terrorist. The government may tap his phone provided there is a law authorizing them to do so in the first place, and provided that that law has been imposed in the interest of, let us say, the integrity or the safety, public order. So if somebody is a suspected terrorist, then the state is given the authority to tap his phone, as it is in the interest of the safety of the state. And any act that this terrorist might be committing or might be discussing or might be plotting over the telephone is then subject to tapping, and that would be constitutional because his right to free speech and expression in that scenario is abrogated, is overridden by the need to maintain the safety of the citizenry. Now let us come to the right to use the media to answer criticism. In the case of LIC versus Manubhai, Manubhai wrote an article suggesting that the LIC was charging unduly high premiums from its insurance policy subscribers. The LIC acted by publishing a rejoinder in the daily national newspaper and its in-house magazine, Yogashema. Manubhai now wrote another article rebutting what the LIC wrote in its rejoinder, and Manubhai requested the LIC to publish his reply in its in-house magazine. His request was turned down by the LIC, and as a result, he approached the court. Now, students, at this stage, I want to pause and explain the justiciability of fundamental rights to you. The Life Insurance Corporation of India, you might ask yourself, is it a private or a public sector company? The LIC is a public sector company. Fundamental rights are enforceable against the state. What that means is fundamental rights are enforceable against union government and state governments. Not only that, fundamental rights are also enforceable against companies that come under a wide definition of the word state. The LIC, the Life Insurance Corporation, is a state for the purposes of the fundamental rights because it is primarily government run and government controlled. Therefore, Manubhai's case is an instance of a private citizen bringing a petition under Article 32 of the Constitution for the enforcement of his fundamental rights and to redress a violation by the state, here the LIC. Now let us return to the facts of that case. In Manubhai's case, the court held that the attitude of the LIC in refusing to publish Manubhai's reply was both unfair and unreasonable. The Supreme Court said that it was unfair because fairness demanded that both viewpoints, those of Manubhai on the one side and those of the LIC on the other, be placed before the readers, and an unreasonable rejection by the LIC because there was no justification for refusing publication. By refusing to print and publish the rejoinder, the LIC had violated the respondent's fundamental right to free speech and expression. The Supreme Court further held that every citizen of this free country, therefore, has the right to air his or her views through the print and or the electronic media, subject, of course, to the permissible restrictions imposed under Article 19(2) of the Constitution, which we have discussed. The right extends to the citizen being permitted to use the media to answer the criticism leveled against the view propagated by him. Let me reiterate this. The right extends to the citizen being permitted to use the media to answer the criticism leveled against the view propagated by him. Here, the LIC, the state, propagated a view against the citizen, and that citizen had the right to rebut, to respond to that view, also in a media that was appropriate. Here, the LIC's in-house magazine was the appropriate medium to publish Manubhai's reply, and the LIC's refusal to do so was a direct violation of his Article 19(1)(a) right to free speech and expression. Now let's come to the right to exhibit films on television. In Odyssey Communications Private Limited, the Supreme Court had to decide whether certain episodes of the television show in question should be prohibited from being telecast. The court, answering in the negative, held the right of a citizen to exhibit films on Doordarshan, subject to the terms and conditions imposed by Doordarshan, is a part of the fundamental right of freedom of expression guaranteed under Article 19(1)(a), which can only be curtailed under the circumstances set out in Article 19, Clause 2. Let's look at the facts of the Odyssey Communications case. Lokvidyan Sanghatana, the petitioner in this case, had contended that the show was likely to spread false or blind beliefs amongst the members of the public. The court, however, rejecting the contention, held that the episodes in question did not violate any law or any right of the petitioners, nor was the serial likely to affect prejudicially the well-being of the people. Maybe the serial was about certain aspects that came under the category of superstition or blind beliefs, but that alone did not justify the non-broadcast of that serial. The episodes, according to the Supreme Court, being telecast on Doordarshan was not likely to endanger public morality and thus could not be restrained from being telecast. The Supreme Court concluded by holding that a citizen's right to exhibit films on television is similar to the right of a citizen to publish his views through any other media, such as newspapers, magazines, advertisements, hoardings, etc., subject, of course, to the terms and conditions of the owners of that media. As long as the terms and conditions of the owners of that media, in this case Doordarshan, were satisfied to deny the broadcast of the show when it did not come under any of the grounds to curtail the broadcast under Article 19, Clause 2, was a direct violation of the Article 19(1)(a) right of the petitioner, Odyssey Communications. Now, let's come to the right against pre-censorship. The Government of India had issued directions under Section 7, Clause 1C of the East Punjab Public Safety Act to the editor and publishers of a newspaper, asking them to submit for scrutiny in duplicate all news stories about communal matters, news and views about Pakistan. This was the case of Brij Bhushan and another versus the state of Delhi. This direction by the government was struck down as violative of Article 19(1)(a) for imposing an unreasonable restriction not justified under Article 19, Clause 2. The court held that the imposition of pre-censorship on a journal is a restriction on the liberty of the press, which is an essential part of the right to freedom of speech and expression guaranteed by Article 19(1). It's really important that you understand what the court is trying to get at here. What the court is saying that yes, you can impose reasonable restrictions, but it has to be post-publication. They struck down any pre-censorship. This case was decided in 1950. However, Some of these views have now evolved, and prior restraints, as they are known, are permissible in certain limited matters. Now, let us actually come to the interpretation of the phrase or the term reasonable restrictions. Article 19, Clause 2 uses the phrase reasonable restrictions, but the phrase has not been defined anywhere in the Constitution or any ordinary law. Reasonableness, as all of you might know, is subjective and not objective. As to what may be reasonable to one person, as what may be reasonable to one person may be completely unreasonable to another person. In order to solve this dilemma, the court has come up with certain tests for determining reasonability. Some of the widely used tests can be briefly summarized as follows. Let us start with the case of OK Ghosh versus Joseph. The Supreme Court said that the restriction imposed should be reasonable and be rationally proximate and in nexus with public interest. If the reasonable restriction is being imposed in the interest of morality, there must be a rationally proximate, that restriction must be rationally proximate to the public interest of morality. You cannot have a restriction that has absolutely nothing to do with morality. Let us say the state bans a film, and it bans a film on cricket, saying that the film is again critical of Sachin Tendulkar, and being critical of Sachin Tendulkar is immoral. There is absolutely no rational nexus with morality there, and that should be struck down. Let's also look at the definition of the reasonable restriction test in the case of the Municipal Corporation of the City of Ahmedabad and others versus Mohammad Usman Bhai. Reasonableness should be determined, said the court, in an objective manner and from the angle of the general public's interest, and not from the viewpoint of the person upon whom the restrictions are imposed. There must be a societal standard, essentially. What does society deem to be reasonable? That is the test of reasonable restrictions. So, students, to sum up the set of modules on the right to free speech and expression, we have seen the theoretical underpinnings of the right to freedom of speech and expression. We have seen how it has developed through the ages, and we have also reviewed how the Supreme Court of India has interpreted this right. We can say safely that the right to freedom of speech and expression is firmly entrenched in the Constitution of India. The court has expanded the right to freedom of speech and expression to include novel concepts as the right to receive information, the right not to receive information, the right to respond to criticism. They have been innovative, and the freedom, therefore, under Article 19(1)(a) is ever expanding and is not confined to traditional understandings of free speech. In the age of social media, such as Facebook and Twitter and Instagram, the role of the Supreme Court now becomes all the more crucial in protecting this sacrosanct right. As demonstrated in this module, the Supreme Court has innovatively expanded the scope to include various rights. And as long as they continue doing so, the society we live in will continue to be a vibrant one, and a society that is based on the right of each person, each citizen, to speak his mind freely.